Hello, this is Winston and Spencer coming to you. We're having a little bit of a presentation today to coincide with a series of webinars that we have previously done, the topic of which was a fresh look at tactics in dealing with court situations. Now on the webinars, it was interactive, which means people could ask questions and so forth. And so it got pretty involved with some of the questions, and so our thought has been to record without any kind of interruptions with questions and so forth, but to record at least some of the major concepts so that you would kind of be able to put it all together. The 3 webinars we did were over a series of about 2 months, and so there was a lot of lag time in between and so forth, so the continuity perhaps wasn't altogether there like we would like to have. So anyway, today Spence and I are going to go over those major concepts in basically 3 parts. Number 1 part will simply be conversation between he and I in regards to the theories behind the process of dealing in courts in certain manners and so forth. The second part will deal with some technology. In other words, we're going to present different ways to handle things in certain situations within the court itself. And then the third part will be basically anecdotes, or we'll go back and rehearse some of the situations that we've dealt with in some of the courts, just on a conversational level, to show you perhaps how some of the technology that we will have presented would blend into an actual real situation, so you kind of get a gist for how some of these things have worked and how you can work these technologies into situations that you might actually find yourself in. We've done seminars for years and years now, it seems, and without fail. Regardless of how we advertise a particular seminar, it seems like court situations keep coming up and coming up and coming up. So this idea of incorporating other people, so you're not just listening to Winston's ideas about how to handle things. We brought Spencer in to give some more input into it, so that you have some of the thought process from different angles. And so again, this is one of the reasons why we've put together, number 1, the webinars, but number 2, now to consolidate the concepts into one package so that you'll have it. In any event, I've been interested to talk to Spencer, quite a bright individual, been doing some of these things with success, so I had a chance to talk to him. And the point I'm making here is that he's also an out-of-the-box thinker. So anyway, maybe Spence, you want to make a few comments, and then we'll start looking at some of the thought process.
Yeah, to say that this is courtroom specific is maybe a little too restrictive in terms, because what I'm trying to get across here is that this is for formal venues, and that's anytime you want to work something out legally or commercially. So whether it's in a courtroom or on a piece of paper when you're going back and forth with a supposed creditor, IRS, Chase Bank, Bank of America, a utility company, you're holding court there. So formal venues, another way to look at those are the rules that are reflected in Robert's Rules of Order.
Yeah.
Same thing, and the same reason. We're here to discuss something we're going to talk about once. We're going to address things thoroughly, but then we're done. And so that thought process is it's well understood with the folks that hold our feet to the fire. And these things are well practiced from folks on the civil side that work in these, clerks and whatnot. And there's no format for folks to sort of practice, discuss, learn out in the public. And so to see the difference between discussing something with the IRS and a courtroom procedure might seem like two different things, but to me it's the same thing. This formal venue process.
Yeah, great. Yeah, one of the things that I like about Spencer, I'm kind of a concept kind of individual, and that is I look at the concept and I just start talking about it. But Spencer actually digs in, uses logic, reasoning. He actually researches things and so forth like that to find out some of these answers and so forth. And he's come up with some very interesting approaches, concepts, and so forth. And like he said, it's not just for a court, but in essence, everything we do where we interact with people, we might call it commerce or we might call it court. But again, it has to do with the interaction between people from different points of view. And so typically, the guy on the street, the housewife in the home and so forth, are used to conversations with family, friends, or the PTA or whatever, and sometimes those are productive, sometimes not. But what Spencer is suggesting is that there are procedures, logical procedures, that would certainly facilitate you in whatever conversation you might be involved in. A lot of people don't realize it, but since certainly 1947, our whole legal system, if you want to call it that, has been based on administrative procedure. 1947, the Administrative Procedure Act. And so what you may not know is that any time that you're interacting with the government or these agencies, banks, or whatever, you're actually holding an administrative court where facts and law can be determined at the administrative level. And that's proof of that. Years ago, the federal government, in order to take the burden off of the federal courts, had set up an intermediate step that they called arbitration. And then the states, they started to think, well, that's a good idea. And so they started setting up administrative courts as a prelude to a formal court, and those were called mediations, arbitrations, and all these kinds of things. And the way they wrote the law, that these courts of arbitration could in fact determine facts and law. So years ago we set up our own arbitration court, and I think I've referred to that sometimes in the past, so I won't go over that. But in any event, you just have to understand that anytime you're interacting with someone on an official basis, well, it's like you mentioned, some of these agencies or just whatever you're involved in, utility company, you're involved in an administrative proceeding, and it is an administrative court where facts and law can be determined right there on the spot. So knowing that, certainly your conversation that you might have with some of these individuals and so forth, you would have to be pretty careful. So in other words, you're not talking to your neighbor across the fence, and so you might want to be aware of some of the techniques and so forth when you get involved in some of these interchanges, because right there on the spot, facts and law are being determined. Is that kind of how you found things?
Yeah. When I first started to apply my focus to these arenas, what I started to see was that to understand at a certain level was to see in an empathetic way through the eyes of the attorney. What is he thinking? If I'm playing chess, how does my adversary see my move? And then my next thought process was, well, wait a minute, now how does the judge see things? I want to get up there from the other side of his bench. How is he seeing what I'm doing here? Now, what are his goals? What does he need to achieve? Why is he saying what he's saying? He's not just freestyling a conversation and asking interesting questions. He has goals and milestones to get to. What are those? And so I attempted to reverse engineer what those goals were by listening to what was said and what needed to happen. And so, that's something else that I think maybe folks need to be able to focus on too, is to not see things just from their point of view in these strategic and tactical environments.
Yeah. Yeah, this is, for those of us who have been through a lot of these different experiences, we can almost basically write you a transcript of what's going to be said in any particular court. And the reason why that is because they have a transcript. They actually have books that they study and learn from. Each judge, if you went from one judge to one county to the next county to the next county and got into a situation similar, they would say the exact same things. Mm-hmm. Now, the advantage that you have is that you're not operating from a transcript. And I'll give you the example of my misspent youth. I wasn't really that young. But anyway, years ago, I was what's known as a card counter in the game of blackjack. Now, what does that have to do with what we're talking about here today? Well, the reason why I had an advantage, and I did have an advantage. Doing what I was doing, it gave me about a point and a half on the house. And so I wasn't gambling because I knew what the outcome was going to be. But in any event, the thing that gave me the advantage was that I knew that the dealer had certain procedures that he must follow. Mm-hmm. In other words, he could not divert from what he was required to do. But I wasn't. Mm-hmm. And so to learn the game and to be a winner at it, I had to do a lot of memorization. But depending on what the count was, mm-hmm. then I could vary from what a typical dealer would have to do. Mm-hmm. And so that's what gave me the advantage, is I didn't have to do what they do. And so a lot of times people have the tendency to mimic mm-hmm. The attorneys. They mimic all these different things.
Just tell me what to say. Just tell me what to say.
Just tell me what to say. And they lead you into that. Uh-huh. They lead you into it. And so to get the advantage in any situation, then do not restrict yourself. Mm-hmm. Only, and so that's why we say when we start talking about out-of-the-box thinking, and that is, well, first off, you have to be able to find something to think about that's out of the box, and that takes preparation. But in any event, eventually you're going to have to do and say and perform differently than what's typical if you intend to succeed.
Mm-hmm. Yep. Yeah, there's milestones that a judge has to get to. There's criteria.
Yeah.
Yeah. And when you know what that is, you say, well, maybe you want to get there, maybe you don't want to get there. Maybe you don't want to get through the proceeding if you're on the business end of an accusation that's just fleecing, an obedience thing, uh-huh. traffic ticket or something. Yeah, so when you know what their goal is, maybe we don't want to get there. We could use it destructively too.
Yeah.
Yeah.
Yeah, so we start talking about interpersonal relationships. They are very structured. Mm-hmm. And they are predictable. Mm-hmm. And that's what would actually give us the advantage, because like you say, if you don't want to get over here, then you know what to do to keep from getting over there. And if you want to get over here and they're resisting you, then you know what to do to move it toward your thing. Mm-hmm. As an example of that, if any of you have been in court and you've listened to an attorney ask questions, a lot of people say, well, I have to answer their question. Oh, no, you don't, or at least in the way they do it, because they formulate questions to elicit the answer that they're looking for. So what I've told people in the past, well, if they ask you a question like that, then restructure the question. And so they might ask you a question, you might think about it for a moment, you might say, well, did you mean to really say such and such? And so you turn the conversation in such a way that the question that you would like to answer is the one that you answer instead of answering their question. And so that, that's
That takes practice.
Takes a little bit of practice. But for instance, it's kind of like the old question, have you stopped beating your wife yet? See, so that's a yes or no, but the original premise was that you were beating your wife, because if you answer the question, then you have just admitted to beating your wife. And so those kind of double bind questions are what we like to get away from, but attorneys are expert in asking those kinds of questions.
Yeah.
Yeah.
Yep. Are you asking me to testify against myself?
Yeah, that'd be a good comeback. Yeah. And this again goes along with administrative, and so and that being a formal court situation, but on the administrative side, you got the same problem, and that is that their forms that they create, that they give to you to fill out, it's their form. And so they're trying to get to a certain place that you might not want to get to. So can you restructure their form or what they're requiring of you so that you can put in the answer that you want? And the answer is yes. Usually on most forms, they might have 2 or 3 categories. They want you to check box A, B, or C. A lot of times they'll have box D, which is other. And then when you check the other, then you get to explain what answer you would like to give. Now, in the event that they don't have a box that says others, go ahead and write other in there. Because administratively, where facts and law are being determined, you have to be very, very careful, because after you fill out that form and sign it, you just locked yourself in to whatever it was that they were trying to put in. As an example of that, this is how I first found this out. Years ago, I was I was working on a job, and they required a security clearance. So I had to pass an interview with I think it was a U.S. Marshal or something like that. So they held this interview, and then they had a lady transcribing word for word everything that was said. And so after, and this is on the spot question and answers. And so I said, after the interview was over with, I asked, can I have a copy of the transcript? And he said, yes, we'll get it right to you. And so they did. They gave me a copy of the transcript, and so I read the transcript over. And some of the answers I gave, I was not satisfied with. And so I simply, in areas that I wanted to change or correct, I simply wrote above it, what I really would have liked to project by that answer, which was either incomplete or a surprise question or something like that. So after I went through and changed all that, I sent it back to him. Now, whether that had an effect on the clearance, I got the clearance. Whether that had an effect on it or not, I can't say. But, from the earliest times, I realized that, in any given situation, unless you have time to think about something, then probably all of your answers and so forth might not be exactly how you would have liked to express yourself. And so when you get into a courtroom situation where the attorneys are bombarding with questions, all this kind of stuff, just slow it down and think about it. Reform the question if you need to. One of my favorite tricks I like to tell people is simply, when you go into the witness stand or whatever, just take a pad and a pen with you, and when they ask the question, just write it down. And so if they challenge you on that, say, what are you doing that for? You're delaying things. You say, well, I'm just, I want to make sure I give a truthful answer, so I'm putting the question down here so I can think about it. And that works. And the next thing, that I've kind of talked to people about, to slow things down, because when they're bombarding you, question, They're trying to frustrate you. That's what they're trying to do with their technology. So I'll give an example. On one occasion, one of my sons was involved in a traffic court, and he did have dyslexia, and it took him a while to read something. But I told him, I said, anything they put in front of you, I said, read it. And I said, if you have to read it twice to understand it, I said, read it twice. And so he took my advice. So they put some papers in front of him and whatnot, so he started reading them. And nobody ever does that. Mm-hmm. Nobody reads a thing to stick in front of him. So they put this paper in front of him, so he started reading it, you know, and the judge was impatient because, you know, they're just trying to run cattle through the chute because they're making money on it, you see. And so anyway, the judge got impatient with him and tried to hurry him up, and finally, you know, I jumped up and told the judge. I was in the peanut gallery, and I jumped up and told the judge. I said, what are you doing? I said, give him time to read it. I said, he has dyslexia. Now, when you can demonstrate in a court any kind of disability, they recognize that right away, because if you have a disability which they don't recognize and try to push you past that, that's a mistrial.
They do it every time.
Oh yeah.
They presume that the defendant is a civilian. When you look up civilian in Webster's or Black's Law, a civilian in Webster's dictionary is an expert in civil law and government at the professor or doctorate level.
Wow.
So, he who is silent appears to consent, and if you're at that level of knowledge, you're doing it knowingly and willingly. There's your disability, is who is at that level.
Yeah.
And so, if you don't tell them, I'm not an expert, boy, you're held to that standard.
Yeah.
In ways you can't even see. And you know, you talk about forms. One of the simplest ways to address that, and is a bare minimum for this tool set, is to understand qualified signatures. Because you can do a lot with your signature without having to disrupt the form if you're on the spot too much. One of the ways I like to do it is to put an ellipsis in front of the signature, 3 dots. And just like in a quotation, it means there's more. I didn't write it, but I don't want you to think that this is complete.
I hadn't heard that one.
Yep, that's exactly what an ellipsis intends to relay to the reader. When you read a quotation from someone out of a book, and the quote's only 2 sentences long, there'll be a quote, there'll be 3 dots. There'll be the couple of sentences that the author wants to include, 3 more dots, and then if there's anything after, and then another quotation.
Uh-huh.
And that's to not deceive the reader that that's all there is. Okay, well, when you put that in front of your signature, that means there's more. It's just not here.
Yeah, okay.
That's one way to qualify a signature. Qualify a signature is many ways. Another one is VC, if you're up against force. VC, and you can see that in an older Black's Law dictionary. It means vis compulsiva. I did this under threat of force.
Yeah, UD. Yeah.
And so, an act done against my will is not my act. So if you don't have any will, you're not held to whatever you just did.
Yeah.
Those are 2 nice ones.
Yeah, we've stressed a lot over the years, qualified signatures, because if you just give a signature, it gives them general jurisdiction.
Yep, you're done talking about it.
Yeah, it's over with. And so you have to be very careful about how you autograph documents and so forth. I had heard about the ellipsis. I mean, that's a really good, interesting thing. We like to use by, colon, and then the signature, perhaps comma, AR. If you look in the Uniform Commercial Code in Article 3, there's, I don't know, about 14 or 15 different ways that you could qualify what your signature is to be used for.
4 is one. If you sign something for something else, it keeps you at arm's length from that entity.
Yeah. So, like I say, there's lots of different little nuances that most people simply aren't aware of
Mhm.
that can make a significant difference in the outcome of what it is they're trying to accomplish.
Mhm.
Yeah, so that's pretty good fun.
Yeah.
You know, you had mentioned something to me today, you know, that I was not aware of, and that's called the fog index. Can you go over that again? So
The Gunning Fog Index is a journalistic standard it's an intellectual ceiling that the general media adheres to, and it's about the eighth. It's set at about the 8th grade, between the 8th and the 10th grade
comprehension
level, and they restrict that by the use of length of sentences and the sophistication of words.
Okay.
And within that, if you put a cap on those two, invariably it follows that your ideas you've just limited your ideas that they can relay.
Uh-huh.
Now they justify the journalistic world satisfies themselves with the excuse that they want to make this available to so that everybody can read this, so that everybody can understand it. Well, now that you know that that's the standard, that just anybody can understand this, it's a straw, or it's a very restrictive bottleneck through which the reality of the world makes it to folks on the other side. It's very restrictive. And so, you know, there's one exception, which is, what was it? The Wall Street Journal.
Yeah.
You know, there's a handful of exceptions, but by and large, it's an incredibly limiting to our mental exercise.
Uh-huh.
And so the reason I brought it up is that folks need to be able to, just because we say it, they're at belief right now. But if they need to think it through and to be able to find their own truth in this and see the reasoning in it, there's a certain mental exercise there that's a little bit difficult. And all of the media and movies and this kind of thing, all of it never challenges our intellect enough to where we have that exercise and we have that practice. And so it's difficult to go from the world that most people are exposed to bam, this kind of conversation all at once.
Yeah. So what you're saying is they're actually dumbing us down
Mm-hmm.
through journalism because of the level that they're willing to express themselves.
Mm-hmm.
Yeah.
And we're not challenged to think.
Yeah. Uh-huh.
And the other thing that's really insidious with television is that all of the other background things that go on with technology, with the news, the things that swirl when you watch a sitcom, when the camera angles change all the time, even though it's the same scene, aspects of our mind have to shut off so that we're not critically thinking.
Uh-huh.
We're not wondering, hey, that wouldn't work. Why are they not doing that? How come when I watch one thing that's in a sitcom is, how come I never see them watching TV? You know, you don't have the capacity of your mind to do that when they're shutting off cameras and starting up new ones. There's all kinds of technology that keeps our mind at complete zero, and so it's hard to go to these kind of conversations and this kind of thinking.
Well, you know, I found that to be the case with sitcoms and stuff where they have canned laughter, because they're telling you when to laugh. They're telling you what's funny. And if you listen to the program without the canned laughter, you may or may not laugh. You may think, "Oh, that's completely stupid. Why should I laugh about that? That's not even funny."
Yeah.
So they instruct you when to laugh. You know, it's kind of like people in some of these big conventions and stuff. They'll hold up the applause sign so everybody knows when to clap.
When I listened to an interview by the producer of the TV show MASH, and they didn't want to put a laugh track in it. And they fought like crazy with the executives.
Yeah.
Executives insisted on a laugh track. And they said, we're not doing it. And so I don't remember what the outcome was. I don't remember that guy's name, Gene something or other. Anyway, yeah, they very well know that these are techniques to...
Yeah. To control
manipulate
the listener to react in the way that they want them to do it. And so translate this fog report concept into technical manuals such as statutes and codes.
Yeah, so when I've put statutes and codes into the fog index form, there's a website, there's a blank field where you can put a piece of text work into it, and it will grade it for you. Is this a 6th grade, 7th grade, grade 14? It'll just keep going up to an infinite level. And I have seen statutes between 25 and 35.
Wow.
I've seen things that Thomas Jefferson has written up around 45.
Was he that smart?
I don't know. It's what the fog index is telling me. And absolutely the most difficult thing that I've been able to measure was at grade 82, and it was a statute that spoke about the interrelationship agreements that when an out-of-state individual drives, it was a driving code, and if you drive into our state by using the roads, that is a sign of an agreement to the following contract. So just coming on in, you're contracting, and it's
82.
82.
So in that frame of mind, then, how in the world would common people, even comprehend something like that?
I couldn't read it.
Yeah.
I had to break it down. What my technique is for difficult text like that is I clip it, I put it on my clipboard, I put it over to a Word document, and I separate it out, and I understand, because some of those sentences are eventualities. If this happens, we're going to go off in that direction, and you have to hold that in your mind, because what if that doesn't happen? Maybe something else is going to happen, and you have to be able to compare all this and hold it in your mind, and to be able to do that, I rewrite it.
Rewrite it how? I mean, for what reason?
Well, to break it down, and to understand in conceptual sizes that my mind can hold all at once, because some of these ideas are so big you can't hold them all at once. You can't understand or read it one time through. Back to speaking of blackjack, the only way to hide a card is if there's the rest of a deck. Right, and so the only way to hide some of these ideas is in a mound of text and paperwork.
Yeah.
So back to this idea of the fog index and getting folks to think things through. I was working with somebody recently, and I was showing them over and over and over again, and they're nodding and saying, yeah, I get it. We got to a certain point where they had a fresh challenge in this commercial process. They had a presentment, a bill or something, and I prepared the answer for them. And I told them, you have to understand this. Oh yeah, I know. But they weren't really reproducing that idea in their mind that I was trying to relay. You need to understand this as if you had written it. They got another answer from the creditor in reply to what they had written. And I said, okay, now I want you to take everything that I've taught you and you attempt to do something. And then I'll critique, I'll guide after you take your first attempt.
Okay.
I had a very thorough presentation for months. And the first thing this individual did is call someone else for their template. Here I am trying to get them to fly on their own.
Yeah.
And they missed the point.
Yeah.
It's not just because I'm providing something difficult for them. If they do not understand at the level of what is being communicated, they can't reply to it. They cannot take what you write for them or what I write for them and work. And I think one of the fundamental misunderstandings of any of these folks that are dealing with this at a certain level is that if you write something fantastic the first time, it solves the problem. It just goes away. It's honored. No, it's arm wrestling. It's a battle. It's a process.
Yeah.
It doesn't just, things don't just go away with one notice or one A for V. The problem is it has happened sometimes.
Yeah, it causes superstitions, what happens.
Yeah, it's not the rule.
Yeah, not the rule. Yeah, I had a similar experience to that. fella had contacted me, and he knew absolutely nothing. And that had never been in court ever in his life. I don't even think even for a traffic ticket.
Yeah.
But anyway, it was an unlawful detainer action.
Yeah.
And so he called me up and said, "Hey, I got this going on. What can we do?" And so then I did swing in, a personal friend.
Mm-hmm.
I swung into action and created the paperwork for the unlawful detainer, and it worked very, very well. Basically for the reason that he could shine it on. In other words, he was eloquent in his presentation, you know, and he presented himself well to the court and everything, so it worked very successfully on that occasion. And another individual came along, one of his friends, and so just used the same paperwork with name changes.
Mm-hmm.
And on this occasion, the judge looked at it and looked at the one who put it in and said, "You didn't write that."
Mm-hmm.
And because they hadn't written it, and they didn't comprehend, they couldn't hold a conversation
Mm-hmm.
about what was in the paperwork. So the judge, it went completely opposite way.
The judge threw it out.
Yeah, judge threw it out.
He should have.
Yeah,
Intent is the spirit of the law. If it's not your intent, don't.
yeah,
I can't hear it.
yeah. So a lot of times over the years, you know, we have presented templates, hopefully as a guide,
Mm-hmm.
and a lot of times it's only a name change, but like you say, the intent of the people who are using the templates, you know, has to be factored in, because intent creates substance.
Mm-hmm.
It's all quantum.
That's what drives it.
Yeah, that's what drives it. And so a lot of times, you know, people say, "Well, do you have a template for this, template for that?" I say, "Yeah." But you know, but still, you have to understand it, because if you are confronted
Mm-hmm.
with what you put in and so forth, then you're going to have to explain it. And if you can't,
Yeah.
out the back door it goes.
Yeah.
And so people need to be aware of that. You know, there's nothing that Winston wrote or that Spencer wrote that's going to make it for you. You know, it's have you internalized what's on that paperwork? And if you haven't, you're in peril. If you have studied it, if you know, I mean, a template's a template, but again, the energy, you know, that you create with your knowledge of it, and so forth, is ever so important. So, word to the wise always, you know, we're happy to share templates and different things that we've used over the years successfully, sometimes unsuccessfully, but after everything is said and done,
Mm-hmm.
you're gonna have to make it a part of you. And if you don't, your level of success goes down and down and down.
Yeah.
That's what we found.
Yeah, and it's also a component to, you know, people banner this word around, sovereignty.
Yeah.
Okay, well, sovereignty to me means taking full responsibility.
Yeah.
You have to take responsibility for a conversation. If you're not hearing things that you don't understand, you have to be able to recognize that you don't understand. Don't nod to everything you hear. And now you're taking responsibility in that conversation. Or if someone does a template for you, someone gets you started, taking full responsibility means understanding it all.
Yeah.
Otherwise, you're just hiding behind paperwork. And I see that more often than not. They want to hide behind
Yeah.
what was said. They don't want to be out front.
Yeah.
That is to me, it's a losing position.
Yeah.
Not just maybe.
Yeah, I have so many people come, you know, and want me to write their paperwork for them, and I refuse. I say, "No, I won't write it for you." I say, "You do the best you can.
Yeah.
You send it to me. I'll critique it.
Yeah.
But you know, unless it's their work,
Mm-hmm.
then you know they don't have the energy in it. And
For the knowledge.
yeah.
Yeah.
And so, like I say, you know, this is woo woo or whatever you want to call it. But when you're, especially in a court, when you go and create paperwork, your energy gets to the court before the paperwork does.
Mm-hmm.
And so your energy has an effect when you show up with paperwork and you put it in. Your energy is already there to support what you've put in.
Mm-hmm.
And so people, you know, that don't have that knowledge and so forth, and don't create the energy necessary, you know, paper doesn't work.
Mm-mm.
People work.
Yeah.
So that's how that goes.
Yeah. Now, there's also some folks, I think, in terms of discussing tactics that are above this step right here.
Yeah.
I'm wondering if there's a certain direction we should go in going back over the tactics of taking things to 3. I don't really have anything in mind right now, but I don't want to.
Well, we'll get into that in the second section. Right now,
Okay.
we're kind of philosophizing to get people in the mindset
Yeah.
that, take responsibility for yourself, take responsibility for what you do. You can listen to us explain how things work, but there's so many variables. You simply can't cover all those kinds of things. Because people send me emails, say, how would you handle this? I say, well, this is how I would handle it. But when you get there, how will you handle it? And so that's the problem people run into without, proper prior planning, preparation, and all those kind of things.
Template. Template.
I'll give you an example of it. I used to have so much fun going to court. Anyway, I got into court, it's one time on some kind of code violation, and so I played with them. I mean, I just loved to do that. And anyway, another fella come to me sometime after that and said, hey, I got this code violation. He said, I got to go up here to the city court, and he said, what can I expect? And I said, well, I wrote it out for him. I said, here's what they asked me.
That's a pretty good question.
Well, it is. And so I actually wrote out what they said, how I answered, what they said, how I answered. And I wrote it out for him. He memorized it. But the problem was, they did. They asked him this question, he answered. This question, he answered. But they asked him a question that they hadn't asked me. And so he just stood there. He was like a deer staring into the headlight. And the judge said, answer my question. Or he says, I'll hold you in contempt and put you in jail. All he would have to have said is, I don't know. But he froze. He had stage fright or something. Sure enough, the judge held him in contempt and threw him in jail.
Yeah.
So again, we can give templates, we can give instructions and so forth, but you very well may run into something that that we haven't. Who knows what's going to happen when you get into those kind of things? So people have to be fluid, and be prepared.
And that's why I say tactics. Understand the process and the tools.
Yeah.
The tools. Yeah. Because if you tell somebody exactly how to build a house and they get a bunch of boards with knots in it, and they just start, or whatever, their materials are a little bit different, and they just proceed on at the same way we did it.
Yeah.
They're going to get a bad outcome.
Yeah, I want to going back to something you said a moment ago, I want to give an example of that, and that is looking at things from their position. What's going on here, and how would you use that to your advantage? I had a friend, he was in prison, and as it turned out, there was a former state judge who was in prison too. He had been a judge, he got involved in some other things. He quit being a judge, he got involved in some financial things, and he did some wrong things, so they threw him in prison. So my friend had a question. I mean, he had a judge he could talk to, on a personal basis. And so anyway, he asked him, he said, well, how do you see things from your position? And he said, look, he said, we use the cookie cutter approach. When something comes in front of us that fits into our cookie cutter or into our mold, he said, we'll deal with it. He says, but if you bring something to us we haven't seen before, he said, we'll throw it out. That's exactly how they looked at it. If something unusual comes in here, they say, no, I'm not going to deal with it, go away. They'll kick it out and so forth. And so, applying that kind of thing, like you mentioned before, if you look at what's going on from their position, then I think you can better structure what your approach is going to be. And so if you do something crazy or unusual, first thing they'll do is send you down for a psych evaluation.
Maybe. I see some different reasons for that. Everything they do in court from the administrative point of view has been reasoned through. And so if you make a misstep, now you're unreasonable. You're non-compos mentis. It's not that you're crazy.
Yeah.
It's that your logic and thinking is unsound. And so if you say I'm not a civilian, I'm not an expert in this stuff, you greatly alleviate that danger.
Uh-huh.
You know, it's the meek that are
Yeah.
going to inherit the earth.
Yeah, we use that a lot on a lot of our paperwork templates, we produce, and that is simply right from the start, to say, I'm not an attorney.
The header.
Yeah, the header, right in there. I'm not an attorney. Then we go into some of the supplemental rules, for admiralty and whatnot, to justify our position, and, making a special appearance, not a general appearance, and all those kind of things. To right from the very start, tell them who we are. So, yeah.
Yeah.
Now, one of the other things, too, that we kind of toyed around with, and that is setting the stage for a conversation in a court.
Mm-hmm.
And so I have suggested that perhaps one of the first questions that someone ought to ask in court would simply be, is there going to be any other language
Mm-hmm.
spoken in the courtroom today other than common English? Now they're going to have to say yes,
Mm-hmm.
because they're going to use illegal terms that have no definition in common usage, because the common usage would be something else, you see. So, if you wanted to prime the pump, so forth, set the stage for all the conversations that would follow, simply just ask them, is there going to be a different language spoken here?
Mm-hmm.
Because legalese is a different language.
Yeah. Or terms of art is another thing too.
Yeah.
That's would be a phrase that would be universally recognized.
Uh-huh. Yeah. Yeah, because like I say, just use the word understand as an example. In legalese, that means something else than what we would commonly in a conversation use.
Mm-hmm.
Because, from time to time, the judge might ask you. I was asked that one time. I think I was in a traffic court or something,
Mm-hmm.
and the judge read me my rights. And then he said, do you understand that? And I said, no. He said, what part of that don't you understand? And I said, any of it. See, because the legal terms, the word understand, was a whole lot different than how we speak it on the street. Mm-hmm. He was trying to get me to enter their jurisdiction, to be the surety for what went on after that. And so there's a lot of words and trips that go on in the courtroom that really foul people up, because you're thinking one thing, but you're in their jurisdiction, so it's their language. Mm-hmm. And so it's good to find out right up front.
Things are statutorily defined as well.
Oh, yeah.
As an example, accident has built into it through statutory definitions that you take full responsibility for. You can't. You can't say someone else has culpability. I was in an accident, but someone else, that would be non compos mentis right there.
Uh-huh.
And a judge will now, if you allege things that are the opposite, you're not to be heard, and he won't tell you. So you just said I was in an accident, but it's not my fault. He can't listen to you anymore, and you didn't see it.
Yeah. Yeah.
Yeah, because people lack curiosity. I wonder what that means. There's not much wonder.
Yeah. Okay. Well, listen. This is kind of a warm up to get people thinking a little bit. We could sit here. We could sit here and talk for hours, but we can't do that. We have limitations and so forth. So, what I think we'll do, Spencer, is kind of cut this level of conversation off here, and then we're going to go into the next portion, which has to do more with a little bit of technology and so forth. Mm-hmm. So let's kind of just suspend this conversation and take it up here in a few moments.
All right, let's do it.